call the House Community Environment and Natural Resources order here. The first order of business is for any piece of legislation. We, for those that are not familiar, we take a motion to hold the bill for further study to keep it in the committee's opinion. That is moved by Representative Wardy to hold 8120 for further study, and seconded by Representative Brady. All those in favor? Aye. Any opposed? 8120 is held for further study. So first, we're going to have Chairman Keeble open this up with description of the bill.
Thank you, Chairman Handy and members of the committee. This bill 8120 proposes some changes to the Energy Facility Citing Board. As I'm sure everybody on the committee and certainly yourself are aware, this is something that the people of Burrillville have been dealing with very closely now for a period of 3 years, and hopefully getting into the final stretches of dealing with that. But we have been told repeatedly to trust the process, and some people in Burrillville and across the state think that the process needs to be re-examined from when it was originally created. Before I get into the bill, I'd like to point out that former Representative Gablinski has drawn my attention to an article that was published in the Woonsocket Call on April 27th. A fair reading of that article would lead someone to believe that this bill is the result of the work of the commission that you and I sat on, the Special Legislative Commission to study the Energy Facility Citing Board. And I did not speak to the reporter before he wrote this article, so I don't think that's fair. Certainly a lot of the material in this bill came out of that committee, but it's not fair to call this bill that committee's work. I know there are many members of the committee here that are going to testify both in favor and against this bill, but at the end of the day, this bill is the work of myself as a legislator. So I just want to clarify that. And I also want to say to everybody that's here that did serve on the committee, including yourself, thank them all very much for their time and effort. And I think it was important. If you like, what I'd like to do is just go through the bill. It is a little lengthy, but I think it's important. On page 2, there is a legislative finding that each host community for a proposed or existing energy facility is uniquely affected by this process. On page 3, we talk about some factors that are to be considered. And one of the factors that we introduced, or this legislation would introduce, is the Resilient Rhode Island Act that you sponsored, Chairman, and I was proud to be one of the primary co-sponsors of. And we really try to give that Resilient Rhode Island Act some teeth through this bill by implementing that throughout. And so that's something the committee will see. On page 4, we add some definitions, and I want the committee to know that the environmental justice definition in paragraph sub G is taken, that language is taken from a Massachusetts statute that was identified to us by the Conservation Law Foundation. We also designate a designee as a person currently employed by the agency that has designating authority. And that becomes important in the next paragraph, where we talk about the board. Currently, the board is established of PUC, DEM, and statewide planning. And you actually have a situation where the director of DEM is serving on this board, which creates all sorts of conflicts, or potential conflicts. So this would change it to all of those agencies could designate somebody rather than have the director on it. Importantly, it increases the board from 3 to 9 people. So PUD, DEM, and planning stay on. The Department of Health is added. The Attorney General's office is added. Both the Attorney General and the Bar Association under this bill would have one appointment of an attorney. In the AG's case, it need not be an attorney, but it would presumably be an attorney that is knowledgeable about matters that would be dealt with in this application. And then the last 2 would be appointed by the community, the host community that is affected. There'd be a resident, that would be one, and then there would be a member of the business community from that host community. That person could be a resident of the city or town, but need not be a resident of the city or town. And that appointment would belong to the highest executive if elected, and if not elected, then the city or town council president. I have spoken with representatives from the Bar Association. I had some preliminary discussions with them where they thought this would be okay, but after they've looked at it, they've decided that that probably doesn't work in light of a Supreme Court decision called Keller. So one thing I would be seeking in a sub-A is to change this appointment from the Bar Association. When I get to the Public Counsel, that would have to change too. On page 5, we changed the requirements for a quorum. On page 6, we add that time periods within this chapter are discretionary, not mandatory. For good cause shown, the board may, at its discretion, extend any and all time periods herein. That language was requested by the town of Burrillville. On page 7, we talk about we give the host community the right to prepare and submit to the board a report as to the consistency of the proposed facility with all of its local ordinances, regulations, and basically what's going on in that particular town. So one of the common themes throughout this legislation is to give the host communities that would be burdened by these things a greater voice. On the bottom of page 7 is an important addition. This is the counsel for the public, and the members of the commission will remember that this was something that was talked about extensively. This is borrowed from New Hampshire. New Hampshire has done this. This is not a completely original idea. And counsel for the public would be able to intervene, and they would be able to be advocates for the public at large. So that's something that people really seem to like and seems to be working well in New Hampshire. Again, the Bar Association would probably not be the proper appointing authority for that, so that's something I'd be seeking to change. On page 8, we talk about there should be 2-year periods for reviews for the board. Currently, I think the board's been in existence for about 30 years, maybe a little more, maybe a little less. We really think that the board's regulations should be reviewed every 2 years. A little further along, on page 8, we talk about a detailed description of the applicant's access to all necessary utilities, including but not limited water, sewer, electric, and gas. For people that are familiar with the proposed power plant in Burrillville, where exactly that plant is going to get its water has been a major issue. They've been denied by 2 water agencies in the town of Burrillville. Right now they have an agreement with the city of Johnston, I believe, but that is subject to litigation in Superior Court. A little further on, we seek more fulsome applications. One of the concerns about this process overall is that as it currently stands, an applicant can submit an application that's not really complete and fulsome. And so one of the things we want to do with this legislation is make sure that the application, at the time it's submitted, gives the level of detail necessary for everybody to evaluate whether it's a good proposal or not. So that's a common thread throughout. On page 9, we talk about a little bit about what happens at the end of the life of the proposed plant. In subsection 8, once again, we reference the Resilient Rhode Island legislation. On the bottom of page 9, we talk about what happens if the application that's put in is deficient in some way or lacks specificity in some way or is insufficient. And it sets forth a procedure that the applicant would go through to try to correct those remedies, including being eventually able to reapply. On page 11, at the top, in subsection F, we talk about advisory opinions. One of the complaints that has come out of the Burrillville proposal is that the advisory opinion process, for lack of a better term, isn't really sufficient and allows an applicant a little too much wiggle room as to what they can and cannot get away with in giving information to boards that would provide advisory opinions. And so one of the things this bill does throughout is strengthens that advisory opinion requirement. In the middle of page 11, subsection A, this would require the applicant to notify the host community no less than 30 days prior to filing its application so that the host community wouldn't be taken surprised by it. A little further down on page 11, we talk about we move it from one public hearing in the host community to 3 public hearings. Now, to the credit of the current citing board, we've had, I think, more than 3 public hearings in Burrillville, maybe as many as 5 or 5, so 4. So this has already been complied with, but we really think there should be a greater opportunity for the public to participate. As you know, if you have one public hearing, someone might be at work, they may have other obligations, they may not be able to be there that day. So 3 gives the public a better opportunity to be heard. At the bottom of page 11, we increased from $100,000 to $200,000 the amount of money that the applicant would be responsible for reimbursing the municipality for, so that the municipality can have its own experts to evaluate the project. That $100,000 number is now 30 years old, so we think it's entirely reasonable to raise that to give the cities and towns greater protections. On the top of page 12, again, we talk about fees for the local communities, so that the local communities that are dealing with this are not burdened by the application, the tax consequences for that. They would have greater tools to be made whole. A little further down, we talk about better notice in newspapers, more notice for landowners within 3 miles for a major or a proposed or existing electric generating facility. So if you're within 3 miles, you're going to be notified that this application has been submitted. On the bottom of page 12, again, we deal with advisory opinions, and here we say that the advisory opinions have to be in order for the application to move forward. Currently, that need not be the case, which is really unsettling. On page 13, we talk about town or city council being able to submit a resolution in support or in opposition to the application. On the top of page 14, we again talk about Resilient Rhode Island. In paragraph 3. And paragraph D is very important. Paragraph D says, in a community like Burrillville, that's already burdened by a large power plant, when you have that situation and you're proposing to add a power plant to a town, in that case, the community's wishes should be abided by. Unless the applicant can show by clear and convincing evidence that the state has a need to cite it there. And this prevents one town or one city or town from being subject to multiple power plants there. On page 15, we increased fines for violations from $20,000 to $50,000. Again, given the passage of time, we think that's fair. There are additional penalties for false statements if an applicant makes false statements in its application. On page 17, we give greater consideration to issues of local police and fire safety for these. Obviously, in a town like Burrillville, that has, not the largest police and fire departments, something like this is of real concern, that if a power plant is going to be cited, that we have adequate first responder capabilities. So this would address that issue. And that is, in summary, Mr. Chairman, the bill. I'd be happy to take any questions from the committee. Yes.
So, net effect on that the current application in Burrillville would be grandfathered under the existing provisions?
We don't believe we can change the process for the current application legally one way or another. But you're right, the effective date is 2019. In the past, as you know, I've introduced bills that would affect the citing board, and some of the complaints where if it's effective on passage, there's already stuff that's going to be pending. So a little bit of time period does make sense, but no, this bill would not apply to this application in Burrillville.
Okay. And how about have there been
totally familiar with how that process works, but to the extent that this bill changes your standards for evidence submittal or whatever moving forward, still under the old process for the ongoing application, or would the new standards apply?
Yeah, I think if you have an ongoing application, if you have an application that's submitted, and probably if you have an application that's submitted before January 1st, 2019, you would proceed under the old rules. It's after that you would proceed under the new act.
Our committee attorney flagged something that jumped out at me, at least, which was about compensation. Actually, the non-state employees, there's a rules in here talking about compensation.
Yes.
That was unusual. Can you
That was taken from, so a lot of states have expanded from small boards to larger boards and have modernized it. So one of the things that's happened in those other states is a mechanism to compensate folks for reasonable compensation for serving on these boards. I mean, I've been to 4 of these meetings in Burrillville. Anybody that's willing to sit on that board deserves compensation.
his concern was just about that, we can have that. That was his concern with this
Yeah.
question, but we can certainly look at that and also if that comes up, we can look at that.
Yes.
Yes. That's why I wanted to ask if you had that. So that I certainly can't disagree. I think that there's some reasonable effort that can be made to help people be able to afford to do some of these things. A lot of people can't afford to volunteer or a lot of this.
Yeah, Chairman, if you look at lines 20 and 21 on page 5, you'll see that the cost of the compensation would be borne by the applicant. So I don't think there's a financial impact.
I was curious too that every 2 years, that I assume that was something we did talk, and I don't remember it specifically, but the idea of reviewing the rules. I'm curious about whether or not we have other boards and commissions that are standing that review their policies and procedures ever. But have you was that 2 years come out of our study commission discussions and things like that?
That was language proposed by the town of Burrillville in their proposed language to the committee. I'm willing to talk about if 2 years is too burdensome, perhaps, but to have something that sits for 30 years without being updated probably is the world's changed a lot since this was originally put in place.
Other questions for green response? Thank you, Chair.
Thank you, Chairman.
Next, someone was asked me to have this sort of start with Ms. Jeremy Daly.
Thank you, Mr. Chairman. My name is Jeremy Bailey from the Burrillville Town Council. First, I'd like to thank you very much. I'd just like to thank, our state legislators and for the study commission. I mean, reading through this, it's very clear that this was thoroughly gone through and there was a lot of thought process put into it. This wasn't haphazardly thrown together. So I just wanted to say I appreciate all the hard work that was put into drafting this. Some of this is going to be redundant because Representative Keeble went through this bill so thoroughly, but I'm going to go through 4 or 5 points that I'd like to point out that I thought was important to put in this bill. One of them was tying this bill with the Rhode Island Resilient Act. That's been on the books for a few years now, and these energy producing facilities, are not only carbon producers, they're also toxic gas producers, and to tying these two together and making sure that they're complying with the existing laws we have on the books, I think is very important, and I thank you for that. Increasing the members to 9, I just think that just makes sense, on a facility of this size and magnitude and how detrimental we all know at this point how these are to the environment. Having more eyes on any application just seems to make sense to me. I like the access to all the utilities before it's docketed. As Representative Keeble pointed out, they really didn't have secure a water source. They had some sort of a quasi-agreement with the Pasco Utility District, and when it was further reviewed, the board decided that, we're not going to enter into an agreement. So this application that's currently in front of us was docketed before they had all the necessary utilities. I like that the members of the legislation, you've added that the applicant pays fees to the host communities, for all the extra work and experts that we have to, hire and look into that. I appreciate you bumping up that fee from $100,000 up to $200,000. That definitely helps, because I can assure you we've spent, 5 to 10 times that amount of money in all of the research and experts that we've hired to go through this application in great detail. Another portion I like, and I'm going to propose a slight change, is on the bottom of page 14, in the middle of page 14, where it talks about host communities who already host a power plant. It says that the state must abide by the wishes of that host community if they don't want it. So if the town council says, you know what, we're already hosting one, we don't want this one, it doesn't make sense, they have to abide by those wishes. What I'd also like to see in there is what happens if a host community already hosts a power plant and that power plant shuts down. So technically, we don't have any power plants in a particular host community. Should a new applicant ever come and want to site another power plant in that host community, I feel that the site that the old one was on should be looked at first and must be given, priority to use that site. Because every time we punch a new hole in our environment, and this particular one in Burrillville is being proposed in the middle of, a state forest, the last, right next to the last Green Valley, it's such an important environmental corridor. If we just keep walking around the earth and keep punching these holes in it, eventually, there's not going to be anything left. So should we need new energy producing facilities in the future, I'm asking that you consider adding some language in there that on host communities that currently don't host one, but there was already a power plant sited in that host community at one point, that they look into that site first and that site be given priority to use. And that's all I have for comments. Thank you very much.
Thank you very much.
Thank you.
Next, let's see. Here,
Thank you, Mr. Chairman, ladies and gentlemen of the committee. Frank McMahon on behalf of National Grid. I have provided you with a pretty substantive argument against the piece of legislation in your packets. I believe Lou has handed it out. So I've got very extensive notes, Mr. Chairman. This bill is of grave concern to National Grid, and I will try to be as succinct and as quick as I can, but this is not going to be my normal, I'm opposed and go and sit back down kind of a bill, because we're opposed to everything, as Representative Hull will tell you in House Corporations Committee. In enacting the Citing Act in 1986, the General Assembly determined at that time that it was in the best interest of the public to coordinate and expedite the review of major energy facilities, and that the board should be established with the authority and responsibility to perform that function. A function that was, prior to 1986, resting here with the General Assembly. So in 1986, you took it from, not you, but your predecessors took it from the General Assembly and put it into the Energy Facilities Citing Board. As Representative Keeble, or Chairman Keeble, has pointed out, this bill makes fundamental changes to the Citing Act and the manner in which major energy facility applications before the board are reviewed and processed. This bill places control over major energy facility applications in local agencies and undermines the board's ability to balance, on a statewide basis, all the interests of all the stakeholders appropriately reviewing public safety, health, environmental, and economic impacts of the proposed facility, while allowing major energy facilities needed to provide a reliable energy supply in Rhode Island to be constructed in an expeditious manner. So major energy facilities just do not relate to power plants. They relate to transmission lines, for example, and that's the greatest concern that National Grid has. So the provisions of this bill and the rewrite of this bill, of this law, are very, very deleterious on National Grid's ability to construct, reconstruct transmission lines throughout the state of Rhode Island. 8120 makes the process that we're associated with expensive and time-consuming process for everyone involved, and would increase costs for ratepayers for those electric transmission line and gas transmission line upgrades. In addition, these projects are needed for reliable distribution or transmission of electricity and the reliable transmission of gas. We've got 4 specific points about this bill. Actually, 5. The first one, I think, is that this bill is very localized in its approach in amending a statute that takes into, or should take, or does take into consideration the entire state of Rhode Island. So our first point is that maybe, if there is going to be a rewrite of this bill, that it be looked at in the context of just that. So there'd be a special provision within the EFSB Citing Act that relates to power plants and things of this sort. Our issue is, again, as I mentioned, overhead transmission lines that span multiple communities at any given time, and same thing with gas transmission. So the second major point that I have basically is that this bill, the amendments to this law, make the process for us unwieldy and would result in a significant duplication of effort. We believe it's a mistake to increase the board from 3 to 9 members. Currently, 1 member of the board can conduct a hearing as proposed, and as proposed, the House bill would require at least 5 members for a hearing. The increase in membership would also likely result in unavoidable conflicts of interest. For example, the Attorney General, Chairman Keeble pointed out. For example, the Attorney General and someone appointed by the Attorney General would sit on the board. At the same time, the Attorney General is responsible for representing the DPUC and Division of Public Utilities and Carriers, which often participates in the EFSB proceedings. In other state agencies, when different impacts come along. So the AG's got a very broad portfolio of clients, if you will, on the state side, which would definitely result in a conflict of interest. 2 of the board members, as has been pointed out, would represent the host community where the facility is proposed. At the same time, the community would have the right to intervene, which it does now, and participate as a party to proceedings. It could be difficult for the mayor or council president of a host community to find local citizens who are, 1, interested enough in the proceedings to participate, and 3, impartial enough to sit as members of this quasi-judicial body. That's a very, very important point. The EFSB is a quasi-judicial body. In addition to the 2 local members on the board, the bill would guarantee host community intervener status, something it already has under EFSB rules, and would create the position of counsel for the public. That is a role that both the Attorney General and the division routinely fill under the current statute. Third point, actually, is Section 42-98-10F and 11D of 8020 would apparently make most of the citing decisions depend on not on the evidence offered for or against the project by the proposed sponsor and the opponents respectively, but on the results of a resolution for or against the project adopted by the host community's city or town council. Interestingly enough, there's no provision in the bill that deals with a situation where you've got a multi-community project and 3 communities vote in favor and 3 communities vote against. It's a situation that certainly impacts National Grid. Our last reconductoring impacted 8 communities on the same exact project. This provision obfuscates the public policy objectives of the Citings Act intent of creating a board to balance those interests of all the stakeholders with need for providing for cost-effective, safe, and reliable gas and electric service to Rhode Island. There are also a number of provisions that would needlessly burden the board, the project proponent, and the public. For example, 8120 would require the EFSB to hold 3 public hearings in each host community before it commences its final hearings. Just by way of example, National Grid has had several transmission projects in the past 12 years that each span 6 cities and towns. The provision would have required 18 nights of hearings for the EFSB members in each of these proceedings. As the EFSB has demonstrated in the recent CREC proceedings, I'm not sure exactly how you pronounce that, but the Energy proceedings, it will hold additional hearings as the situation or as the host committee determines it, if there's a demand. National Grid representatives have attended EFSB evening hearings on some of its projects where either no members of the public showed up or only a few did. And in fact, the last project that National Grid did, we had evening meetings in all 6 or 7 communities and not a person showed up. So an incredible sense of waste of money and so forth. Currently, parties interested in obtaining information and providing comment for multi-town projects already have the option of attending all these hearings as you move forward. The House Bill 8021 would also require National Grid to send notice of any hearing to property owners within a mile of a proposed project or corridor by certified mail. In addition to the resources required and the cost with obtaining and mailing notice to thousands, if not tens of thousands of residents for a linear project, this requirement imposes a significant burden on National Grid and even those people who receive the registered mail and have to go to the post office and pick up those letters. Finally, 8021 imposes significant additional expense on the project proponent, National Grid in this case, who must pay for the reports of environmental experts, which it currently does under the current statute. The costs, including attorney fees of intervention by each host community, the charges of counsel for the public, and the compensation for new public members of the board. Again, a cost that gets borne by ratepayers, and as you can see in our situation, rather unwieldy, rather unworkable. Finally, there are a number of provisions included in 8021 that appear to be solutions in search of problems. In 4298-7A, for example, 8020 would require each host community to prepare and submit a report as to the consistency of the proposed project with all local ordinance and regulations. Currently, the citing board asks each city and town zoning, planning, and building boards and departments to provide advisory opinions regarding the project. It is shocking how many communities do not comply with those advisory opinions when they're requested by the board. Similarly, in 4298-7D, 8021 provides that each host community shall be granted intervenor status as of right. Rule 1.10A1 of the rules of the EFSB rules grants the right of the city or town to intervene, the city or town in which the proposed facility to be located by the filing a notice of intervention. Finally, 4298-9F states that the board shall seek advisory opinions from zoning, planning, building. As noted above, this is the board's current practice. So, as you can see, and as I hope I tried to draw out for you, our situation, our problems with this legislation is much different than what Chairman Keeble and the folks from Burrillville are trying to get at. Be happy to continue our conversations. Chairman Keeble and I did have a telephone conversation a few days ago, and I sent him a copy of our letter earlier today. Admittedly, it was rather late, but we've been a little bit behind in getting some of this stuff evaluated, some of this stuff reviewed. A lot of people that had to put input into it. So with that, Mr. Chairman, I'd be happy to try to entertain any questions of the committee or of Chairman Keeble. But that's National Grid's position on the legislation as it stands right now.
So, do you guys not feel like the DEM might have conflicts, things like that? I mean, correct? That's what I was thinking about when you were saying. I do agree on the conflict concern. That's something I've expressed some concern about, but I think we're going to work on these things. But you don't think that the director of DEM also has a responsibility often for enforcing laws around some of these questions?
Right. So in a situation where, in our case, we go through a wetland or we go over a wetland or something along those lines, yeah, I suppose there is. But then the board, the remaining two, makes that decision. So I think there are lots of scenarios in which, conflicts become apparent. I think this bill makes it worse.
Other questions for Mr.
Mr. Chairman, so Frank, you have a number of specific concerns with this language. From a bigger picture perspective, Chairman Keeble talked about how it's been 30 years since this has been updated.
Mm-hmm.
Do you think, in general, that merits maybe these you have issues with these specific, but 30 years ago there were differences. The climate crisis that we didn't know as much about back then.
Sure.
We did know about it, and the oil companies were already making plans based on it, but certainly we know a lot more about it now. So do you think that point in general that there could be changes?
Sure. So thank you for your question. I am not a policymaker, although I like to be a policymaker from time to time, particularly when Ray Hull is sitting to my right. But that's certainly a fair and reasonable question for the EFSB, for all boards and commissions. I think the chairman pointed out when's the last time all the boards and commissions have looked at their rules and regulations. So National Grid would welcome an opportunity to be part of that process if the EFSB decided to take a look at its 30-year-old rules and regulations. I did not know that until I heard the Chairman's testimony. So as for the public policy implications of it all, that's really not my decision. That's really what you folks are here to do, thankfully. Again, National Grid would be happy to participate in the process if that were to happen.
Other questions? Thank you very much.
Thank you.
And so you've got, I worked perfectly with this, you've got a similar
Yes.
document for us here somewhere.
Yes, Mr. Chairman.
Thank you very much. Let's see. Person here, John Pacheco. And if we sort of had a pro and con, if folks could, first try not to repeat, but Counsel, I appreciate that also. Try to be somewhat succinct. Thank you. That's the word I'm looking for.
I plan on it.
Counsel.
Thank you, Rep. And thanks everybody for sitting on that board to review this legislation. My name is John Pacheco. I'm the Burrillville Town Council President. 3 years I've been dealing with this. If the current legislation was any good, we still wouldn't be, this power plant would not be built. I'm not going to reiterate everything that Mr. Keeble and Mr. Bailey said. However, I will say the town of Burrillville has spent well over $1.5 million vetting this process, this power plant already. That's not fair for the citizens of Burrillville to have to vet private companies' project. I won't get into particulars, but you know, we are lacking a lot of information for this project. When the advisory opinions were put forth from our town, that was 2 years ago. A lot's changed in 2 years. The biggest thing is 2 years ago, I went around to almost every town council and asked for their support in our opposition to the power plant. We had 32 towns in the cities and towns in the state of Rhode Island to support us in our opposition, almost unanimously. The thing that resonated the most was the lack of local control, lack of local input. So you got 32 cities and towns, the councils of 32 cities and towns in this state, that's their biggest concern, the thing that resonates the most. That is what resonates with us. This is not an anti-labor or an anti-business bill in any stretch of the imagination. If the applicant had come in with all the ducks in a row, the plant would have been approved 2 years ago and it'd be up and running in about a year. But that didn't happen. So we're just trying to correct that. It's been very frustrating for the people, not only the people of Burrillville, but people throughout the state. Am I right? A lot of people here that are not from Burrillville. I've been at all those hearings in town, the ones we've had with the citing board and the ones we've had with the applicant, and the council meetings that we've had that went into 1, 2 o'clock in the morning. This tries to eliminate that, that's all. And tries to make it fairer for whatever city and town. I appreciate National Grid's opinion. I think that could be easily solved by giving this legislation to strictly maybe 100,000 megawatts, 100 megawatts and higher. You may want to consider some language in here that deals with solar and wind, because those projects are getting bigger also. That's what I'll leave it at that. I'll take any questions anybody has. If anybody needs any information, the town has reams and reams and reams. That's one of the big reasons, the impetus behind increasing the size of that board, because there's no way in heck the 2 members of that board have been able to read all the information. There's got to be 30,000 plus pages. If Mr. Bianco was here, he'd be able to confirm that. It's insane. I've actually looked at every page and gotten to the conclusions. That's where, it's faster that way. So I'll take any questions.
Representative Hall.
Thank you, Mr. Chairman. Mr. President, where's the project? Brick and mortar, the building's up, fenced in, what's going on?
what's going on? Nothing's happened yet.
There's nothing?
Nothing.
No construction, nothing?
Nothing at all. We're still dealing with the Energy Facility Siting Board. We just started 3+ years. We just started hearings last week. Funny enough, they had opening statements from both sides, and now we don't have another hearing until July, I think. Am I right? July?
Other questions?
So this has been a pretty contentious project, but hearing you just say that if they had their ducks in a row, it would have been built 2 years ago. So are you personally in favor of the project?
I wouldn't say that at all, no.
I just, what you would...
No, I'm just saying, well, here's one small, there are 55 structures going to be proposed for this site. We have plans for 2. How do you build something that's that big and one of them is a storage shed? Could I go to your town and build a house and, give them plans for a dog house and then build a 4-bedroom house in your town? It wouldn't happen. That's what I mean by that. I mean, the applicant, and that's what's caused a lot of the expense because it's too vague. It's not clear enough. And and I'll give them this. The power plant company of energy sitting 4 years ago, looking at a map of the United States. That site looked like a great spot. I wouldn't, we got power lines, we got gas lines. There was a water source. Now you fast forward 4 or 5 years later, the gas line hasn't been expanded. That's being held up in Mass and Connecticut. So they may not even have enough gas to run the plant. They don't have a water source. We're still, still waiting for plans. So that's what I mean. If they had come in and they had everything going on, like anybody else, any builder, any developer would have to come in and have their stuff together in order to get approved. If they had done that, then this would be happening. It'd be hard to fight it, in other words. Okay, thank you.
Greg Hansen.
So I have, 23 copies. I don't know who I give this to for you. What you asked for, right? What?
Yes, I'm sorry. The record show that landscape are here and let them go to the affirmative on the
So I want to touch on what Council President Pacheco said. Talked about local control, and that's an issue that why this act was initially passed by the General Assembly is to kind of take away local control for the good of the benefits of this, all the citizens of the state. I certainly can understand the town of Burrillville want local control, but I can tell you it's a very slippery slope, and I'd be very careful going down that slope because these facilities, whether they're power plants, whether they're airports, whether they're landfills, are utilized by the citizens of the entire state of Rhode Island. They're permanent for all the good of all the citizens. Give you an example. A couple years ago, the Warwick City Council voted 7-0 to stop expansion of the airport. And if that occurred, the $100 million expansion of Green Airport would never. If they succeeded, the $100 million expansion of Green Airport would never occur. We've never had travel to the West Coast, non-stop travel to the West Coast. We'd never have non-stop travel to Europe, and I think and other destinations. And I think that expansion has greatly enhanced the economy of the state of Rhode Island and the quality of life of the people of the state of Rhode Island. So if you give a community too much local control, I mean, certainly it should have input. I think it can go too far, and I'd be very careful. I would also say if you do that in this instance, I'm sure the citizens of Warwick will be lining up with some sort of petition and with some bill to get more control over airport expansion. I'm sure the citizens of Cranston will be lining up to get some sort of legislation, maybe even to relocate the state prison. And of course, the citizens of Johnston will put in legislation to cap the landfill and not have any more landfills in Johnston. So I think the implications of passing legislation like this are far greater than another power plant in Burrillville, and I think that's something that you should really weigh very heavily. In terms of this particular legislation or any other energy facility generating facilities, I fear that if this legislation passes, there'll be no new energy facilities built in Rhode Island, and I think that would hurt all the citizens of this state. I think it would hurt our economy, and I think it would hurt the employment effects of the citizens of our state also. It will also increase our energy bills. In particular, the proposed, it was commented on by a couple before me, I think the proposed makeup of the board is flawed in terms of the Attorney General having conflicts. I think that you may have too much local control also. In terms of the provisions of the legislation talking about requiring the EFSB to abide by the town council and city council's wishes, I'm not sure what type of legal standard that is, and I fear that that'll effectively not only kill energy facilities, new energy facilities in that community, but in every other community in the state of Rhode Island. I also had another couple other items I was concerned about, but the suspension of the docket if sufficient details to allow agencies to consider advisory opinions aren't available. I'm not sure what that means. Sufficient details is not a defined term. If an applicant doesn't provide a agency with the information that they can't make an opinion, they should say that in their opinion, and then the EFSB board will have to take that into consideration, probably adversely, into the applicant's application for a permit. So I would just be very careful. I certainly understand where the citizens of Burrillville are coming from. I know they want a lot of say. I would respectfully disagree with the council president, because I know there's two sides of every story. I've heard Invenergy's side on a lot of those delays, and I don't know who's right. I'm sure that both sides subjectively believe they're correct, but I'm not so sure you can lay all the blame on the developer. Certainly in terms of the Resilient Rhode Island Act, I think that's laudable. My understanding this particular project will comply with the Resilient Rhode Island Act. Other than that, I have no further questions. If anyone has any questions for me, I'm more than happy to answer them.
Questions for Rick?
Yes.
Just one question. I appreciate what you're saying, and about different communities, and of course, I've been fighting a couple of issues locally in Cranston, and facilities owned by the state, one involving sex offenders, another one involving being mentally violent, being moved to a training school, and this has been an instance where it's a state-run facility, but it is in the city of Cranston, and there were not any public hearings. There was no notification, to the community. So I can appreciate what you're saying in one respect. In another respect, we're struggling with a couple of issues where there's been, no type of, we haven't had no part in any of it, and it's been kind of forced on us. Not kind of, it has been. And so, to have that dialogue. So, is there a happy medium somewhere between what's been going on and what you're saying as well? That's the question.
I grew up in Garden City. When I was young, a couple of prisoners escaped. We had to lock our door, all that stuff, and I grew up in a single-family house, a single-parent household, and we were scared a couple times, not a lot, but a couple times. So I know what you're saying. I think it's a balancing test, and there's no bright line. And
that's kind of my question. If it's a balancing act, how would you change the legislation to make it? I mean, that's kind of
I think having local folks on a state agency, judicial agency, make a decision about their community, I think is bad precedent. I think it's not good. Because also, number one is they're probably subjective. They're not keeping an open mind coming into the proceedings. I mean, it's a judicial proceeding. You're supposed to be impartial. I think I would suspect that, knowing the way politics works, they'll volunteer to be on it to kill the project, or one way or the other. And so I think it's unfair to put them in that position. But I think that you would start there. I think in this particular case, the Town of Burrillville's resolution has been accepted into evidence. A resolution against the project has been accepted into evidence, and I think it will be weighed. To what extent that's going to be, there's really no standard, as far as I know, in the act. I mean, they're certainly going to comply with zoning and things like that, I would think. Although I think they can supersede that. But it's a balancing test.
Well, I was at a conference in the summer, last summer, and it was, they talked about energy plants and facilities, and they were talking about one state, particularly maybe Wyoming, I forget, but they had a contest, there was cash prize involved for building, the best facility possible. This one recaptured CO2, didn't use water, and, I know this was an ongoing issue, and I said, why didn't we build something like that? Why, I know there was other risk factors involved, and that's why some people are opposed to it, the water, the air, or whatever. And I just said, was this a matter of a company coming and saying, I'm going to build this, as opposed to, say, everyone getting together and saying, can we build the best facility, one that, say, captures CO2, one that doesn't require use of water? And, to see that it was such an innovative project in a western state where they built something that was so environmentally friendly, I don't know, I'm not against building either, but in this day and age, we're so sensitive to these things, could this plant or company or another company have built something that could have been more, more environmentally friendly, or something that was as innovative as the one I heard about this summer? So that's been an ongoing concern of mine as well. And again, I'm not against building stuff, but can we have done something better, I guess?
Well, that's up to this body, but I will say one thing. Just, people I represent are citizens of the state of Rhode Island. We're pro-environment just as much as anybody else. We want a good environmental project, but on the same token, truth be told, there's a cost to that, and so it's a balancing test of the cost of energy for people to be able to afford their energy bill, companies to be able to afford affordable energy in a competitive environment. So I don't know much about that situation, but I do think it's a balanced situation, and I think that it's up to this body to determine how they want to balance that.
Yeah, and then the state has given out grants and money, and all kinds, millions of dollars, all kinds of projects. And so, seeing a state that's giving out, prize money for the best project and then building that, maybe the state could have been a little bit more proactive while this was all going on to try to make it the best project it could have been. That's the only other comment I would make.
Well, that kind of goes into, I think, Rep. Keeble's comments about the state regulations being looked at every 2 years. I deal with a number of the state agencies, and I think that's a common challenge, and it's a common issue. It happens a lot. I think it's a worthwhile endeavor. But I would say to you, it's also a matter of resources. So, so I think that kind of leads into that issue.
Thank you so much.
No problem.
Yeah, I just have a quick question, Mr. Mincy. I heard the council president indicated that this was about submitting the plan for the actual building of this. Is that a problem?
I don't think so. I can tell you that I'm on an email trail. I get more emails for data requests and information. I'm blown away at the amount of information that's given. I think that Invenergy's lobbies, I'll let them speak for it, but I think that they've submitted a lot of information. They disputed Mr. Pacheco's comments. I believe they have. I don't want to speak to them. I think they submitted a lot of information. They had certain plans, and circumstances changed. People backed out of certain agreements, so it caused them to modify their change. I think that the EFSB determined that the application was complete, and then this has been a 3-year process. And during that 3 years, there's been changes. There's been environmental changes. There's been changes with contractual relationships that they had people. I think to not allow for the changes to occur, I think is you'll never have a power plant built. I will say, if you do it, certainly you're going to allow due process. And I think in this case, the EFSB board has allowed that. They've suspended the docket, I think, at least once and maybe twice. And I think that was to afford all the parties a fair time to respond to the changes. And by the way, as one last thing, these energy siting facilities, they take years no matter where you are. They're contentious, they take years no matter where you are.
Well, there's environmental, if I may, Mr. Chair. So, the analogy was that, I'm going to come into your town, I'm going to build a doghouse, you're going to okay that, and then we're going to build the rest.
I can tell you that
You're telling me it's much more than the doors.
I can tell you that the amount of information, he also said, by the way, that there's so much information that 3 people he didn't think would read it all. And so,
Well, 30,000 documents.
right, so I
is a
mean,
lot of documents.
so I mean, the information's there. And I'm sure that the town's asked for it. I believe that they eventually has responded. If they haven't responded,
We have inventory that's going to come up too, so I mean, because I know you're not part of you're not one of the.
I'm not, but I just took the liberty because I'm actually part of the proceedings in front of the ESB, so I felt I could comment on it.
Because I've seen comments to the contrary, and I don't want to jump into that in terms of state.
But let me just say this much, that this is a thorough adjudicatory process, that everybody's going to be heard, and if that's a valid argument, the EFSB board will take that consideration, and I'd be shocked if they give them the permit.
Other questions for Thanks for.
No problem.
All right, next, let's see, Tim Christopher.
My name is Tim DeChristopher. I'm a resident of Pawtucket, and I'm also here as a board member of the Rhode Island Interfaith Power and Light, which represents 30 different churches across the state that work to protect creation and to fight climate change. And we are here to strongly support this bill, which we think is very overdue to update the way that the Energy Facility Sightings Board acts. And in particular, there are 3 major things that we really appreciate about this bill. The first of which is that it finally names and brings into legislation the concept of environmental justice. And over the course of the past few decades, that has really been a predominant dynamic in the way that energy facilities and a lot of polluting industries are cited in this country, is that the most vulnerable communities, marginalized communities, poor communities, and communities of color have these polluting projects dumped in their backyard and oftentimes get very little say about it. And so the second thing we appreciate is that this dramatically increases the public participation in the process, both by expanding the board to have members of the public on the board, both by the formal role for the impacted communities, and just by making it more transparent, even specifying larger ads in the newspaper to let people know what's going on here. All of that is really critical to increasing the democracy in how these things operate. And the final thing that we're really excited about by this is that it does bring the reality of climate change into the decision-making process, which has been a glaring omission of the way most of our regulatory agencies in this state and in this whole country operate. Which is why we've so thoroughly failed to address the climate crisis for the decades that we've known about it. And so that's long overdue to finally address that. And in particular, I'd like to point out there on page 3, in line 11, where it strikes the line that sort of conflated natural gas and clean coal technology, with air quotes, with renewable fuels, which was always a misleading thing to do, to put all those in a similar category. And so I think this provides a lot more clarity and sets a clear guideline about the greenhouse gas emissions. There are 2 things that we would like to request in addition for updates to this. One is on page 4 under the definitions, in letter E, where we get a definition for clean coal technology that defines it by producing emission levels substantially equal to those of natural gas-fired power plants. And that, again, is a really outdated definition that comes from the time when people thought that natural gas power plants had about half the emission of coal-powered plants. But since 2005, with the dramatic increase of fracking, most studies that have looked at this have found that natural gas that comes from fracking, which is pretty much all of our natural gas in this region of the country, has emissions at least as high as coal-fired power plants. And so that sort of makes the notion of clean coal technology meaningless. And I also see that since clean coal was stricken from that page before, I don't see it anywhere else in the document, so it may be entirely appropriate to just eliminate that whole definition, which I think would be fitting, because clean coal has been an unrealized promise by the industry for decades that has never actually manifested into reality. So it may be time to put that myth to rest. The other thing that I'll point out is on page 9, under the section on applications and contents, under number 7, that talks about the study for the alternatives. And in the last line of that, it says the study shall include estimates of facility cost and unit energy cost of alternatives considered. And I would encourage this body to clarify there that when talking about those facility costs and alternative costs, that they make sure that they're talking about for the lifetime of the facility, those costs for the lifetime of the facility. Because one of the main dynamics in our energy economy at this point in time is that renewables have been dramatically dropping in price, and fossil fuels have been steadily increasing in price to the point that they're now pretty close to equivalent. And those are trends that are likely to continue, almost certain to continue, because fossil fuels are a non-renewable resource that are getting ever more scarce, and renewable energy is having consistent technological breakthroughs in achieving economies of scale. And so part of the reason that we're seeing this huge push for new natural gas and other fossil fuel infrastructure around the country right now and over the past few years is that the industry recognizes that the economics for building these facilities are moving against them, and that window where it makes any economic sense to be building new fossil fuel infrastructure is rapidly closing. And so that's why we're seeing a lot of applications for these power plants and pipelines that we don't actually need right now, because the industry knows that they need to get them in with this window before renewables become far cheaper than natural gas, and that once we make the upfront costs for this infrastructure, that then we're kind of locked in to using it for its life cycle. So I think we need to clarify that when we're looking at costs, we're looking at the costs over the life cycle and the projection of those costs to take this into account. So again, I just want to say that we strongly support this bill and see its necessity in the fact that over the past few years, every fossil fuel infrastructure project, particularly every natural gas project across the country, has had substantial local opposition that often results in the local communities engaging in civil disobedience to physically stand in the way of the construction of these projects because they felt that they have been so locked out of the decision-making process. That's the status quo right now. It's not a sort of a smooth regulatory process of building these things. It's a process where communities are so outraged that they have to resort to civil disobedience. And so this is a very necessary upgrade that finally brings their voice into the process, and we appreciate that. Thank you.
Any questions? Again, you said that you represent a group. I didn't hear what.
The Rhode Island Interfaith Power and Light, which is an affiliate of the National Interfaith Power and Light, and here in Rhode Island we represent about 30 churches. Yes. Yeah. It's all sorts of faith communities. Yes, faith communities. Thank you.
But I was trying to get back to pros and cons, but your next one might pro side.
Sorry for the
Sure. I want to first recognize that Representative Brett Markowski has joined us and would like to further affirmative on both for the study. Let's see here. Elizabeth Super. She's here on behalf of the Greater Providence Chamber of Commerce in opposition. Scott, again? So Scott,
I'm there for it, like, I don't like it. I think so. Sure.
You don't mind if my wife's birthday and you know you're not boss in my life? Yeah, I got some testimony there for you, Mr. Chairman. So, Mr. Chairman, members of the committee, Michael Sabatoni, President, Rhode Island Building and Construction Trades Council, Vice Chairman,
of Build Rhode Island, business manager of the Rhode Island Laborers District Council, representing District Council, about 10,000 members, both public and private, 7 local unions, building trades, 15 local unions, close to 10,000 with the good work that's been done up in this building the last couple of years to get Rhode Island's economy back on the move, which is why this bill is so important that it does not pass, because nothing will thwart the economy more going forward than an unpredictable, escalating, rising cost of energy in the state of Rhode Island, which is a fact. So this bill, you just peel away everything. I don't even want to get into the specifics of it. What does it do? Basically, what it does is it ensures that an energy generating facility will never be sited again in the state of Rhode Island. You know, if we build the one in Burrillville, it's my hope at some point that we won't have to build further generating facilities such as the one in Burrillville as renewables catch up. But unfortunately, there's one fact that people want to ignore. And the fact is that natural gas is going to be the premium source for this area of the country for the next 30 to 40 years. And that's a fact. That's from ISO New England, the operator of the grid. You know, it makes no sense if someone's going to come up here and say that, well, we want to get these plants built because we want to hurry up because the cost is escalating, so that we can get them in the ground before it doesn't make any financial sense anymore. When you look around and you see Somerset just over the line in Massachusetts, why that plant closed? That plant closed because it cost too much to operate. It was a coal-fired plant, which is a good thing. You take a look in Plymouth, Massachusetts, why that plant is closing, a nuclear power plant. And Vermont Yankee, up in Vermont, another nuclear power plant, who've got another 20 years of life. Both of those plants. Fact. Why are they closing? Because they can't compete to the cost of the natural gas. Not renewables, natural gas. So it makes absolutely no sense for someone to build a plant that's not economically feasible and invest over $1 billion with plans that are already done. I'll send you the link gladly of a project being built right outside of Scranton, Pennsylvania by Invenergy. Happens to be a 3-cycle plant instead of a 2-cycle, which is what was proposed in Burrillville. The pictures of the 1,300 tradespeople building it, the 2.5 million man-hours that are going into that construction. They didn't just design a doghouse and they're going to go stick, they don't know what they're doing, they're going to stick up in the woods of Burrillville. That is just simply not true. And I'll be able to show you that. What this legislation does is basically kill our ability to supply the needs of the energy for the state of Rhode Island, for both business and, quite frankly, kitchen tables. 54% increase for National Grid a few months ago. Cold snap 2 days away from blackouts, burning oil because of the constraint on the pipelines. We can't get natural gas here. During that cold snap, the state of Rhode Island was paying the highest natural gas prices in the world, not even in the United States anymore. This is a fact. In the world. And you're flaring gas off in the Midwest. We've got the cheapest energy in the world, but we can't get it to the Northeast because we can't get additional pipeline capacity to bring it here. That's a fact. The Energy Facility Siting Board has one major factor: need. If it's needed, they'll decide it. They'll weigh all the factors. 2 members of the host community, I heard mentioned. You know, I know what it's like to sit and make tough decisions. So you heard mention of citing things, airports, corrections. I live in Johnston, 50 years. I sit on the Resource Recovery Board. I live 3 miles from the landfill. I'm the chairman of the landfill. Been on that board for 10 years. I know what it's like to deal with my community. I know what it's like to balance environmental issues. I know what it's like to do for the need or the good of the state of the other 39 communities. Johnston didn't raise its hand and say, yeah, we'll take the dump. Give us the landfill. You know what we went through a few years ago. Mocks, jokes. Wasn't pretty. Things got to go somewhere. Airports got to go somewhere. Landfills got to go somewhere. Power plants got to go somewhere. We didn't just spin the wheel and pick Burrillville. You heard it mentioned, the mainline gas line goes through one community in the state of Rhode Island. It's the town of Burrillville. The compressor station, a high-density compressor station is in the town of Burrillville. That's where the infrastructure is. So when you need to site another one, and you got to keep in mind the cost and the need, which the EFSB will do, the further away you get from the infrastructure, the more it costs. And that's why they picked that site. Heard mention, maybe we can make the project better. Rep. Lancia. This will be the most efficient gas power plant, I know for sure, in the United States, might even be the world, with the best technology to date known to man for that type of facility, the one that's proposed in Burrillville. So I don't know how you can make it better, but that's what the facts are. Definitely in the United States, I'm not sure in the world. You heard mention that they had to spend a lot of money. The town of Burrillville, $1 million. They didn't tell you where they got that money. It came from Invenergy. Invenergy stopped paying them a few months ago because of misleading statements, etc. They signed an accord, an agreement, and that, they were able to release that money. I'd suggest a good portion, maybe if not all of that $1 million, was Invenergy's money that they then took to fight the power plant, of an agreement that they signed. Didn't come out of the taxpayers' pockets. Most, if not all, of that money. In closing, just let me say this. I get climate change. We're not climate change deniers, the building trades. We built the offshore wind farm. Half the people that are fighting us in Burrillville fought us in Block Island. I love green jobs. A job's a job, green or any other color. I don't care what color it is. If it puts guys to work, we'll build it. Solar farms, wind farms. Look in the mirror tomorrow and you ask yourself, how are we going to get from there to here? Because it's not going to happen overnight. There was a solar eclipse. I wrote an op-ed a couple months in the paper. I'm going to send it to you again. There was a solar eclipse that came across the country 4 or 5 months ago. You all remember, maybe longer. California gets half of its energy from solar. When that solar eclipse occurred, it was fast start natural gas fired power plants such as the one proposed in Burrillville that kept that grid going as that thing rolled across the Southwest. These type of projects actually enhance and create more renewable projects because of their ability to come online in less than an hour. Manchester Street down in Providence takes almost 23 hours to come online because of the technology. The new one, less than an hour. You want to build more renewable projects, you need more projects such as this. And the other thing is, if you're really worried about climate change, and I believe it helps with the emissions, the Ocean State Power is running right now. When we build this one goes online first. The more efficient plants operate before the less efficient plants. We had a study commission. Has anybody seen that study? I've got the last email that said the last meeting to schedule the next meeting.
Just rewrite back the bill.
Yeah, but I'm just saying,
we talked about a lot of things.
Well, just let me say, do me the courtesy as someone that spent a lot of time, as well as yourself, Rep. Handy, on that study commission. It's a little disappointing that we went to those hearings. There was no final report, and next thing you know, there's a piece of legislation. There was no final report of that study commission. Last email I've got says to schedule the next meeting. Unfortunately, I missed the meeting on March 1st. And next thing you know, here's a piece of legislation. Why do we have that commission in the first place? I implore all of you, I know it's hard to do, that this is a bad bill. It'll send an awful message, not only to the kitchen table, to the men and women that you represent in your communities, it'll also send an awful message to the business community. And with that, I'll stop.
Questions, Rick Paul?
How close are you to the Algonquin line? Is that where it's going to come off?
Right next to it. A couple of miles, maybe less.
So that's why. But I know it comes around over to East Providence, sure.
The main line. Well, distribution lines come down through that to the pump station. That's how they push it down this way.
That's why the location was shown.
That's correct.
And you'll take directly the gas right off that line and won't interfere with anything else in other facilities.
They have the capacity to draw off that line. That's correct.
Other questions, Mr. Secretary?
Thank you very much.
And
Mr. Chairman, thank you. My name is Paul Rosselli. I'm the president of both the Burrillville Land Trust and the Rhode Island Association of Conservation Commissions. And I was a member of that House Study Commission on the Energy Facility Citing Act. And along with Mr. Sabatoni's wife, it's also my birthday as well.
Happy birthday.
Happy birthday to you. Mr. Chairman, I want to get back to what this legislation is all about. In the past half hour, all we've heard is misinformation, lies, and stuff that's not even in the legislation.
So focus back on the bill.
So I want to focus right on the legislation and what this legislation does. Number one, provides for more transparency for local communities. Period, end of story. Number two, it puts in a process where there are more experts, more public officials, more state agencies, more people who can't do this, who can't get on boards, an opportunity to take part in the democratic process. That's number two. Number three, it starts the process of eliminating fossil fuels for the production of electricity in our state. That's what this legislation does. This legislation also is about jobs in the economy. Because without this legislation, we are going to be in permitting land, citing dark holes for the next 4 or 5 years before this project ever puts a shovel in the ground. In the past 3 years, the only people who have been employed for this project have been attorneys and consultants. Nobody else. Not one laborer, not one electrician, not one engineer, not one union member. This legislation provides a better process to get us somewhere. Now, some will say here today that this is going to make the process more cumbersome, more complex. This legislation is not in isolation. This was not proposed, this was not written, this was not generated from the meanderings of some few people on a commission. In many ways, Rhode Island is playing catching up. We're trying to catch up to New Hampshire, Massachusetts, and even the state of Washington that are doing this process better, more transparent, and faster. There's one other piece of misinformation that was labeled here, and that was this is going to somehow delay transmission wires and substations. If you look at page 3 of the legislation, you'll see a very clear indication of what this legislation is geared for. And that is for energy projects of 40 megawatts or more. Not transmission lines, not substations, not transmission corridors, not burying cables underground, but any major production facility of 40 megawatts or more. I would also like to point out that the fossil fuel industry that's represented here today is gearing up for a battle that'll pit many of us in what they're calling us as green elitists, when in fact most of the union members like to hunt, fish, take their family camping, and support through their votes open space farm referendums. Mr. Chairman and committee members, this legislation does a lot, but it doesn't do enough. Now, I've submitted written testimony that will add significantly and make this legislation even more important and actually let us catch up to places like Massachusetts, Connecticut, New Hampshire, and the state of Washington. One very important addition. Let's give authority to the EFSB chair to be allowed to respond to citizens' comments during public hearings. As as the president of the town council said, we've had 4 or 5 public hearings, both in the town of Burrillville and Charlestown and a few other places. At no time is the EFSB board members allowed to respond to citizens' questions or comments. That's a time for dialogue. That's a time for understanding. That's a time for responding to what this board is all about, this legislation is all about. Transparency and catching up. And to be quite honest and quite direct about what this legislation does, and then I'll end. We are on a path to end fossil fuel use for the production of electricity. And that's where we're headed. We're headed for one very good reason. And that in this legislation, we finally give teeth to the Resilient Rhode Island Act. Finally, Mr. Chairman, there's a reason in this legislation for the payment for people who take part in this, on this board, on this energy facility siting board. If you think about who sits on these boards, just about every member is paid. An attorney who is there, a union member, an expert, the commission members.
Go ahead, sir.
That's okay. What I'm suggesting here is that the reason that there's a stipend in there for members who want to participate in that is that a lot of people can't afford to be there. They can't afford to be on boards. They can't afford to take time out of work. They can't even afford the money it takes to get a bus to get to the State House or to someplace else. And you're asking these people to sit on the board for free when everybody else is getting paid? So if your legal staff is asking that question, that's the answer. Mr. Chairman, the Burrillville Land Trust owns 214 acres surrounding the proposed power plant in the middle of the woods in northwestern Rhode Island. We at the Land Trust, along with many other organizations, Burrillville Against Spectra Energy, fighting against natural gas, Keep Burrillville Beautiful, Keep Rhode Island Beautiful, the No New Power Plant folks, and many, many, many others all throughout the state are looking for this legislation to move the state forward and to catch up with those other states. Thank you, Mr. Chairman and committee, for your time.
Any questions?
I don't know if you can answer it, but the need for energy in the future as we move forward, or maybe it's for a question might be for the company who wants to propose this, probably not for you, because where we're at now, and I see other facilities closing down because they're obsolete, like the coal-fired plant.
Sure.
But we still need a need for energy. I'm just trying to.
Sure.
Put myself into a place where if I say no, and we need the energy, where will we be?
Yeah, so if I may answer that from the perspective of someone who spent the last 3 years steeped into this project, I would refer you to isonewengland.com.org. Which one? No, well, it's one of those. And May 1st, every May 1st, matter of fact, just a few days ago, ISO New England releases their report about the needs for New England, and they project 10 years in advance. In other words, every May 1st, annually, they look at the next 10 years. And historically, what you would think, to answer your question, yeah, you're right, the need goes up. The need goes up, and the companies like Invenergy come along and say, yep, we're going to make some money. Let's go.
Well,
but in the past 10 years, that needle has actually leveled off. In the past 4 or 5, the need for New England has gone down, mostly because of energy efficiency programs, alternative energy, such as solar and wind, and for the appreciation that climate change is real.
So just, where here does it talk about a member of the union? I see no membership on this for labor.
I'm just saying that should be included, that somewhere in this.
That's why I was asking about that. That's why I was asking this question.
Yeah. Yeah, so right now, and most of the boards, when the FSB does their hearings, or some of these other panels, most of the folks who are there, like the hearings.
So we're not paying the people that are in attendance.
No, we're paying the people who are on the boards. That's what I meant.
Okay, all right. What are your thoughts on that question of conflict, though? We've got an intervener. Like, for instance, should we say that Invenergy should be able to be on the board as well in this particular case?
This piece of legislation is modeled under a couple of very specific states, New Hampshire being one of them. And New Hampshire likes the idea of putting the applicant on the board. Why not? You've got somebody who's right there, who can answer questions, who can take testimony, who can provide information, who can rebut certain things. Why wait? Why? We've been in this process for 3 years. Just now are we getting to a stage where that testimony is going to be discussed and rebut.
To me, the side, again, you asked about having this opportunity for a response from this board, this group, but in reality, they're supposed to be sitting in judgment, and that's not normally the role that judges play. And similarly, the role that judges play from a town or from a developer, normally those would be the advocates for a position. In fact, actually, you can have an argument that a town could be an advocate in favor of something.
In favor of something, sure.
And also then having a very clear bias.
Yeah.
You know, we want it here because we don't want it over there. We don't, that's
Sure. So, no, you're absolutely, and as a 3-person panel, you would expect, but as a 9-person panel, those types of issues, I think, could be addressed very, very easily. And it's in the legislation as to who's appointed and where they come from.
Yeah.
If there are tweaks here and there, that's fine. But the premise here is to catch up to some of these other places that are actually doing very well.
So the last question, because you said that this is explicit only to those large energy facilities. But as I read it, it actually essentially then would say that National Grid wouldn't even need to go to an energy facility citing board for these things. That actually excludes them entirely, if that's the case, because it does say when the board sits for any purpose related to a proposed or existing facility, that's the board established. So I think this is what National Grid's concern was.
Sure.
To be fair,
And I think it's a valid concern, and some legislation should.
To be fair, National Grid's position is the definition of major energy facility, page 3, line 34, after the semicolon, transmission lines 69 kV or higher, over. Page 4, line 5, and facilities associated with the transfer of oil, gas, and coal via pipeline. So I'm not sure what the gentleman is referring to, but clearly the vast majority of cases before the EFSB in the last 20 years have been related to transmission lines and electricity and transmission
And
lines.
no issues there. We are.
Also, I'm not going to have you respond to it, but I just wanted to ask that was my concern, was that I don't think it does what you're saying in that regard, and I want to make sure that clarify that. I think what you're saying that you're trying, that's the effort, and I think that's what the sponsor's effort is, but I just wanted to clarify. You were saying it's not that, and I'm saying, let me put my chair hat on for a second to say, wait a minute, let's look where I'm seeing that part. But any other questions, though, from Mr. Roselli? Thanks, Paul.
All right, thank you. Thank you, Mr. Chairman.
So, let me move back. Scott, did you want to speak as well?
Good evening, Mr. Chair, members of the committee. Mr. Chair, by the way, my nickname, I just made it up. I'm Mr. Succinct. So, I hear what you're saying. There's been a lot of discussion and debate about fossil fuels versus green energy, about no power plant in Burrillville, power plant in Burrillville. We're here to discuss the merits of this bill, and that's quite simple. I'm Secretary Treasurer of the Rhode Island Building and Construction Trades. We're opposed to this bill. I think the evidence is quite clear. The citing board as it is right now has done diligent work. I think the 3 members sitting afar, looking down at state issues, are doing exactly what they should do. What worries me, first of all, expanding a board to 9. Too many cooks spoil the soup. Too many cooks will never boil the soup. I mean, you think the process is lengthy now? 9 people, I see it lengthening forever. And localized interest. You know, with the rise, and I understand it, the rise of NIMBYism, and it's not my backyard, it's never in my backyard. Talk about a doghouse. You won't be able to build a doghouse with a little solar panel on it. That's the road we're going down here, and that really worries me. If every town and city could weigh in on a statewide issue, because it's about the state, the benefit of the state, I think that's troublesome. Thank you very much.
Any questions for Thank you very much, Scott. Next, we can go to Jason Olkowski.
Thank you, Chairman, committee members. Appreciate the time to talk before you tonight. My name is Jason Olkowski, and in full transparency, I was one of those members on the commission. We had the opportunity to hear from a lot of different stakeholders that are involved in building energy facilities and maintaining lines, and getting a chance to hear from a really broad range of constituents. And I think that I see a lot of what we heard in those sessions represented here in this bill. So it was not done in isolation, it was not done in a vacuum. I see much of that represented here in this bill. So I just wanted to open with, do we need to update this? I hear a lot of folks advocating, essentially, let's just leave it alone. 30 years. 30 years. 30 years. What's changed in 30 years? Look around you. A lot, even in this old building, right? Phones. The world has changed quite a bit in 30 years. The pace of innovation has changed, industries changed, energy markets have changed. Also, how we generate and transmit electricity has changed. So why in the world would we not look at this bill and examine it as well? This bill stands like a monument to 30 years ago, as if we're celebrating the past. It stands like a monument to a time where we didn't have rising seas, where we weren't facing climate change, where we didn't have massive changes in how we generate and distribute electricity. So let's not be confused, and let's see through the smoke screen and say we should take an opportunity to evaluate this act. Now, evaluate the merits of what's actually in this bill and what's being proposed, and not the discussions about should we build plants or not. This bill is not going to stop us from building all plants. I don't believe that's the intention of this bill. I don't see that in here. I don't see anywhere in this bill that says no more plants approved. I don't see anything like that. I see a bill that gives more transparency to the process. I see a bill that gives a voice to the citizens that are impacted by this process, the citizens that elect this body whom we are supposed to serve. Yes, we need to look out for the needs of our state, for the energy needs of our state, for the energy costs of our state, absolutely, but we also have to look out for our citizens in the state. And the reality is that our citizens have not had the voice that they need in this particular process. Now, I can tell you that when you look at evaluating something, we should listen to stakeholders, a broad range of stakeholders and constituents. We should also look at lessons learned. We have lessons learned because we're going through a process right now. We've heard how long and lengthy this process has been, and we should listen to the voices of the people that have been most involved in this current process. We should not belittle their voices. You heard the president of the Burrillville Town Council, who was recounting to you what his own zoning and building commissioners have said. They have been through the process, and they're telling you that they don't have enough information, that they need more transparency. They're telling you that they need more information earlier in the process. And if you look through the details in this bill, that's essentially all the types of things it's doing. It's pulling forward some of that information that gets confused and muddied and buried in a lot of other detailed documents. It pulls it all forward and says, you gotta tell us that all up front. Be honest. What is this facility? What do you want to build? What's it going to look like? Okay? And that's not in the very beginning of this process. So I would encourage you to look through the details of this bill that were put in there by people that have actually gone through the process. And I think you're going to hear from more of them tonight. And let's leave aside all of the other facts and misinformation from people that have not gone through the process. So let me just highlight a couple other things before I close. Does this stifle investment and economic growth and say no new power plants are going to be built in our state? It does not. I didn't see that anywhere in the legislation. I didn't see anywhere where it says don't build any more power plants. Businesses are used to process. I deal with big, huge businesses every day. We can work through a process if that process is clear. And frankly, I think that makes the process more clear. The process is a little confusing. Some things aren't defined currently. So an applicant gets into the process, and then you start telling them, we need this, we need that. All those 30,000 documents that you heard about that have been flying across the wire and email, those come after the fact from requests. And so now the businesses are like, well, you need me to go get that too? Why in the world would we not want to make it clear for a business that wants to come do business in our state, here's exactly what the process is, here's exactly what's going to be required of you, and here's the burden that you need to meet for this to be a complete application. I think that's important. I think that will help our economic development in the state and not hinder it. So I think it falls to you as legislators to strengthen and modernize the energy facility citing back, and I think the good news is that you have a strong bill in front of you that provides a good framework. If things need to be tweaked, if they need to be tweaked for National Grid to exclude certain projects, you guys can do that. I think you need to keep in mind the core elements of this bill and what it's trying to accomplish. And I can just tell you, and there's other people up tonight that are going to get into some of the details and why they're important, but I can just tell you this bill is so important to a community member who has gone through this process. The state needs this bill. The affected communities need this bill and the things that are in it that are very, very important. Increasing the members, that's kind of a no-brainer at this point, right? I mean, every other state has these commissions, boards, they're structured slightly differently, but they all have more than 3 members. If you want to debate, is that the right 9, you can certainly have that discussion.
If you could cut to the chase a little bit, I mean, you're repeating a little bit what we've heard, so if you don't mind.
Yeah, I certainly can. I certainly can. And the point being, other states are doing this. We need to catch up. Rhode Island, in some ways, is a laggard in this process, and we're trying to catch up. I think this does that for us. We need your support. I'd ask you to consider the tweaks that you need to make, and then let's put this bill forward. It would mean so much to the citizens of Rhode Island. Thank you very much.
Questions from the floor, Council? Thank you very much. Let's see. Back and forth. Pros and cons. Chris Boyd.
Thank you, Mr. Chairman, members of the committee. The previous witness made me feel rather old because 30 years ago I was chairman of the Joint Committee on the Environment, passing the Energy Facility Citing Bill Act. So, you aged me, right? Frank, you were here. Frank was in this. But for the record, Mr. Chairman, I represent Invenergy, the applicant in Burrillville. I also, for the record, represent Exelon Energy. It's a Fortune 100 company, one of the largest energy generators in the country. Also, I represent Emera Energy, which owns and operates Tiverton Power, a 300 megawatt gas facility in Tiverton. All 3 of them have extensive renewable portfolios. I think energy companies are, as previous witnesses have testified, changing their style of business, recognizing that renewables are the future, that this industry is transforming toward a larger renewable portfolio. It's a matter of when this will occur based upon technology and investment.
Are you representing the others as well?
No, I just wanted for the record to indicate that I also represent other. So I in a way, I am expressing some opinions as far as
generation industry. I want to thank the comments of Chairman Keeble. I know this bill is well-intentioned. It was, I think it is an attempt, a good faith attempt to modernize the EFSB. On some of the comments he made, I apologize for my testimony being somewhat disjointed because he eliminated some of the concerns that we had, and I thank him for that. And I also want to adopt, by reference, the grid testimony because I think that was spot on, just the concerns that the generation industry would like to raise relating to this bill. Because we do believe that if you adopt the legislation as written, it would have the practical impact of eliminating any future generation applications. The national market does look at states and how they cite and how they approve applications. And I think this bill would say to the industry that Rhode Island would be hostile to any further applications. So if you pass the act, I don't think it would be applied because I don't think you would see the industry interested in Rhode Island in the future. And if just I don't want to repeat the testimony, but I do want to add a couple of examples of the real concerns that we have. One is the Attorney General's role in this. Under the proposed legislation, he gets 2 appointments. And as it was previously pointed out, a lot of times the Attorney General will actively be involved in matters before the EFSB. So you would literally have the Attorney General sitting there listening to arguments from the Attorney General's office. And we think that is an uncomfortable and probably inappropriate relationship to have to create an appropriate way to cite these, to look at these applications. Chairman Keeble did discuss the Bar Association. That was a head scratcher for us. And I know he had indicated that there will be some other proposal, but we would caution that any private group this is really an executive function of state government, and we don't think any private group should have the authority to appoint an individual to an authority like this. Local appointees, that's certainly, again, the General Assembly sets energy policy. That's something that this General Assembly will decide, but we absolutely agree with Grid that this applies to transmission lines. It's one thing to build a facility, but if you can't plug it in, it's of no value. And we don't know how this would be applied if the transmission line would run over 5 communities. Do you add 10 more members? We're having a difficulty trying to grapple with this, but we do agree with Grid on that issue. In fact, I know the ISO New England has been referenced. Their 2018 energy outlook cites the biggest hurdle for wind power, to increase the use of wind power in New England, is the transmission concerns. So you may be trying to eliminate gas-fired energy production, but at the same time there may be some consequences to increasing wind. The provisions relating to costs are very concerning, and I think that's where the strong signal to the industry is, don't come to Rhode Island. The provision, and again, I think Chairman Keeble addressed the fact that perhaps the bar is not the right appointing authority for the attorneys to serve counsel for the public. But again, the provision of the Act does require that fees for the counsel for the public, including expert witnesses, shall be paid by the applicant. And it allows the appointee to appoint a lawyer or lawyers. We're very concerned about the wide open scope of a provision like that. It's good for lawyers, but it may not be appropriate for a good system of vetting these applications. Also, on the issue of compensation to the board members, that is required to be paid by the applicants. And we just want to raise an issue of whether or not there's some discomfort that the members of the board are being paid by the applicants. I'm not sure that's a good public policy result either. The other one that's really concerning is a wide open blank check to the host community. There is no restriction, there is no check on how much the host community can spend in reviewing and whatever, whether they're advocating or they're opposing the application. There is absolutely no check on how many lawyers, how many experts, all of those items that are indicated in the bill. That's a very chilling provision for any potential application. One of the things that may be different than what's been discussed so far is the future of transportation in Rhode Island and in New England. I just want to give you one fact. CO2 emissions in New England. In 1990, transportation, in the CO2 emissions amounted to 64 million metric tons. The same year, power plants emitted 45 million metric tons of CO2. In 2014, transportation emitted 67 million metric tons. Power plants were reduced to 25 million metric tons. Power plants have become incredibly efficient compared to what they were many years ago. Transportation has not. So if you look at the issue of electric vehicles, and there is no question, and I'll put my hat on as representing General Motors, we're working with the governor's office. He has initiatives coming out on autonomous electric vehicles. There is no question that is the future of transportation. I don't think anybody debates that. The question in Rhode Island will be, how will we charge those vehicles? Will we have the capacity? Will we continue to pay more than 50% higher costs than the rest of the country? How competitive an economy will we have when our charging costs are 50% higher than the rest of the country? These are issues that I think you should think about before you make dramatic changes. And in our opinion, it would eliminate any future applications for power plants in Rhode Island. Finally, I just want to say, since 1986, when the EFSB was adopted, we've had Ocean State Power, Johnston, Manchester Street, Tiverton. Now, some people may say that's a bad thing, but think about where Rhode Island would be with their energy capabilities, capacity, and cost if we didn't. I'll leave you with that, and I'd be happy to answer any questions if you have. And I want to say, though, this is not about the matter that's on the EFSB docket. This is about how future facilities will or will not be cited in Rhode Island. Thank you, Mr. Chairman.
Questions?
Thank you.
Leah Donaldson.
Thank you. My name is Leah Donaldson. I am special counsel to the town of Burrillville, and the town strongly supports the passage of this bill, as you know. I'm going to try not to repeat what everybody else has said, but let me make a few points that may have been missed or may have been glossed over. One is that while Burrillville is currently going through this with the Invenergy process, this is something that can affect almost any city or town in the state, because while I agree that this involves the transmission lines, and we can talk about a potential, cutout to make this be only related to the power plant process, this doesn't just have to do with natural gas. This bill, as it currently stands, like not even before we amend it, involves renewables like solar and wind. So if a company comes in and wants to do a renewable project, which we would love to have happen, they're going to be subject to this legislation as well. So as we move forward with our ideas of trying to bring in those types of energy into our communities, we want to update this legislation. The primary objective, when I was one of the folks who helped to originally kind of go through the legislation and see where we could, possibly improve it, the primary goal was to create a meaningful role for local communities without a local veto power. The town understands that this should be decided by the board, not the community. Everybody's already addressed some of that, so I don't want to get into that in too much detail, but a town wants a voice. Everybody wants a voice. They want to feel like they've been heard, and the town understands the complexity of their community. The city understands the complexity of the community the way nobody else can, right? The other piece of this that seems to really have been brought out in this process is ensuring information is promptly provided to the EFSB at the beginning. And right now, for example, the way the legislation currently reads, if an application is submitted and it's incomplete, which it probably would be, right? Maybe you missed something, whatever. The board can send it back and say, this is incomplete and here's why. If the applicant then submits that exact same information without correcting the mistakes, the board has to docket it. Has to. That's the way this is currently worded. So this proposed bill would allow to make sure that the board gets what they need from the beginning. And, I know it's already been said, but if I'm being asked to do something, I happen to be a rule follower. If you say to me, here's the details I need, I can give it to my expert and say, look, build me a package that has this in it, and we'll submit this to the board. And right after that, the board will have to accept it, because guess what? Tick, 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 here are the boxes. We can move forward with a much more efficient process. Let's see. One thing that hasn't been talked about yet is the 30-day advance notice to a host community. So right now, the host community finds out once the application's been docketed. I'm not sure how familiar anyone here is with major land development processes in the state. That's Rhode Island General Laws 45-23. Under that process, there's a pre-application process where there's some dialogue with the boards that are going to approve it, the zoning boards and things like that. This 30-day advance notice allows for the beginning of a conversation, possibly beginning a good neighbor. We want to be a good neighbor, and what can we do to get you on board with this application? What can we do to... So this 30-day notice, I forget where we pulled it, which state we pulled it from, but that would allow to begin the process without the town feeling like they've been bombarded all of a sudden with this application. Let's see. Another thing that has been discussed briefly is the fact that this would ensure that the EFSB considers all the municipal resolutions that are put in. It doesn't require them to abide by them. So in this case, for example, in the Invenergy case, 32 cities and towns submitted a resolution. This would require the EFSB to consider them, address them in their opinion, and say, we decided to give it very little weight. We're not going to listen to the cities and towns. Or we decided to give it a lot of weight. And, we wanted to really think about what our cities and towns like. But it doesn't require them to do anything, it doesn't require them to listen to what we have to say. They just have to consider it. Let's see. The issue of compensation's come up a few times. The idea of the applicant compensating the board is not unusual. Under the major land development process, when somebody wants to build a house, for example, they're going to pay an application fee. That application fee is exactly how we fund the board. So the idea of the applicant funding the process is not something that is unusual for us to continue here in this legislation. Attached to my testimony is a one-page highlighted summary of what we think is important in this legislation. I will not go through it again because you guys have heard it all, but I was someone who was involved in originally reviewing this legislation and reviewing all the neighboring states to see how they do this process and what could we take to bring into our state and what did we not like and that kind of stuff. So it was a very educational process to go through that, and however this legislation turns out, I hope that we're able to bring it forward in some way, even if not everything gets adopted because it's contentious. I hope we're able to bring Rhode Island forward in some way for the citing process. Thanks.
Questions from Ms. Donaldson? What it was brought up earlier that the town was really essentially compensated for those costs. Is that accurate in the current situation?
In the current docket, the town, were proactive in negotiating with Invenergy to come up with our good neighbor agreements. The good neighbor agreements, for example, that they're going to pay nearby property owners some compensation for their property values diminishing, those types of things. We also did something to make sure that when they leave Burrillville, that they will leave it as they found it. So we did a very detailed agreement about when they decommission this plant.
So this would have been 2.5.
Right, this was a long time ago. So part of that was coming up with the tax agreement, and part of that involved, we combined the good neighbor and the tax agreements together. And the tax agreement did provide for upfront payments that we could use in however we wished, and we were very upfront about the fact that we would use those to fight the plant.
Other questions? Thank you very much.
Thank you.
Linsky asked on the con side here. So a few people about that.
I'm pretty tired. How about you?
Still got a bunch of witnesses to go. So stay otherwise, yes.
So I think Mr. Sabatoni, Mr. Boyle, Mr. McMahon, John Simmons' written testimony sums up a lot of the factual stuff that I will not repeat. I will take Chairman Keeble at his word that he did not say that the commission spoke and made these recommendations. However, somebody did, and somebody planted a story in the Woonsocket Call indicating that the commission members submitted this legislation. We did not. We never took a vote on it. We never had final say in any of that, which is disturbing to me that I committed an awful lot of time in meetings to have no discussion at it all on the end and the recommendations. If I had known that was the case, I would have not have participated. I'll just clear up a couple of issues and make my point on those, and not to be repetitive, is that the Resilient Rhode Island Act, in its addressing carbon, Rhode Island does not have vertical lines. There are 7 power plants that have shut down, including the Brayton Point one. That air mixes up, blows back and forth, back and forth. It is very hard to look at what just the state is producing because it is moving from state to state. So I would ask that you not be too misled by that, because there are an awful lot of power plants that have shut down, as was mentioned before, that were much more toxic than the one presented now. This discussion here really has to do with local control versus control for the greater good. And as Mr. Sabatoni aptly pointed to, airports, landfills, all of those things would never be built if there wasn't a higher 2,000 square foot look at this, 2,000 feet up look at this, to make a decision for the greater good. We need all those things. In regard to renewables and their ability to replace, renewables will be duplicative until there is a day where their energy can be stored and used for peak demand and be able to come on demand like that. Until that time, it's all duplicative, and that we need to produce power within a very short period of time. And the only way to do that is central power distribution. There was mention of ISO New England. ISO New England CEO President has clearly said, we are 30 or 40 years away from being able to depend on renewables until storage becomes a key factor in it. Until then, we need to have fossil fuels. And I think gas is the way to do that, with one of the most efficient plants that has been proposed in the country. I think that's all I need to say based on what everyone else has said here. I'm certainly on record at many hearings and given much testimony before the EFSB and before the PUC in regard to our position, which is TechRI, the Energy Council, largest energy users in the state, who employ tens of thousands of people. And our position would be to oppose this bill, not because of the changing of the EFSB. There were state agencies that studied this and came together, DEM, PUC, OER, and made a recommendation that I see no evidence of that in the recommendations that were made here today. and there were no direct discussions by them with the board. They may have had discussions I'm unaware with Chairman Keeble. So there are two versions of this out. I would suggest that you look at the other one. It's part of the public record. It was submitted at the last meeting, and I think you'll find a much more objective look at this bill, which is 30 years old, as it said, and does unquestionably needs to be updated.
So there are 2 people signed up to submit testimony looking for that mentioned. Johnson, Rybeck, as just mentioned, submitted written testimony in opposition. The Rhode Island Business Coalition has submitted that written testimony in opposition. Yes, for that. So next, Brian Daniels. Brian Mason. Okay, he has, on behalf of the Rhode Island League of Cities and Towns, is in favor of the legislation. I believe we might have, I'm not sure. Next, Amy Moses.
Thank you, Chairman and members of the committee. My name is Amy Moses. I'm the Rhode Island Director of the Conservation Law Foundation, a nonprofit environmental advocacy organization working throughout New England. Full disclosure, Conservation Law Foundation did have a seat on the study commission, and I appreciate the efforts of the study commission chair, Keeble, and Vice Chair Handy. There's a lot of good information exchanged on that study commission, and in addition to serving on it, Conservation Law Foundation, like other members of the commission, did submit suggested changes. Some of the changes that we suggested are in this legislation. As the chairman has asked, I don't want to repeat many of the things that have already been said tonight, but I do want to direct your attention to the actual bill and what it proposes to do. This is forward-looking legislation that's talking about the future of energy siting in Rhode Island. The current law in the books hasn't been looked at comprehensively in over 30 years, and a lot has changed. So while a lot of folks here have experience with the Burrillville siting project, and we can learn from that experience, this is really about looking forward and what energy is going to look like in Rhode Island in the future. There are 2 important pieces in this legislation that I want to draw your attention to that CLF strongly supports. The first one is including the Resilient Rhode Island Act in this bill, putting it on the books so it makes clear that the Energy Facility Siting Board needs to consider the Resilient Rhode Island Act. The statute's already been on the books for several years, but it's really important when we think about power generation that we keep in mind that there's already laws requiring us to reduce our carbon emissions. So we think that's a great feature of this legislation. The second important point I want to point out is the inclusion of a public advocate. We suggested that that be included in this legislation. It is not a novel concept. Other states have public advocates as part of their energy facility siting process. This language is in large part consistent with the New Hampshire proceeding. I've talked to my colleagues in New Hampshire. The public advocate position works really well in New Hampshire. And the way the EFSB is set up now in Rhode Island, we don't have a public advocate. There really isn't a voice of the public. While the folks in Burrillville have really rallied the troops and have been meaningful participants, it is important that there is a public advocate, particularly when plans are proposed in environmental justice communities. I know that's already been mentioned tonight, but there are communities in Rhode Island where the members of those communities may not be able to rally the troops, if you will, hire experts, get involved, and it's important that there's a mechanism for them to be represented. So those are 2 really key features of the legislation. We support both of them. In addition, there's several other small adjustments which we think are important. As has been mentioned tonight, it's really important that agencies have the information they need to issue the advisory opinions. There's language that would relax the intervention, the standard to intervene. Getting back to the Burrillville situation, there was a party that moved to intervene and they were not granted intervention in the process, and there were lots of questions raised about that. It's now become a little bit moot, but we think it's important that the standard for intervention is relaxed. In addition, requiring that all materials need to be submitted before the application is docketed is really important, so people know what they're dealing with. You don't want the train to leave the station when it's not full. There's also an appeal in increase in the number of days for an appeal, which we think is important because it's a large undertaking and this is more consistent with other appellate statutes. So in general, we're supportive of it, and I'm happy to answer any questions.
Thank you very much. Any questions for Moses? One that you're talking about the advocate for a second.
Yeah.
I think actually it's been talked about as much together. When we talk about environmental justice, people would say that it's not as much capacity to step in for level stations. And the third is obviously still very working, working family too. But I think we're talking about. Do you see the role of that public advocate as a bit more general, not so much necessarily about the town where it's going or the community where it's going, or do you see it as sort of both, or I'm just curious about your thoughts?
This particular language for this public advocate would be seeking to protect the quality of the environment, including advocating for environmental justice matters. So that would be the focus of this particular individual's role.
And what about that concern that I think my friend Dan brought up, but we're concerned about too, about the idea that we have these sort of other parties that, in theory at least, have some of those roles. I know that the BPUC is supposed to sort of have some of that role, and the Attorney General is supposed to. I'm just curious about. I mean, I know as a person who's sometimes been on the outside, pushing in on some of those things that I haven't always been excited about, the level of activity in the past years, and I'm going on in those places. But
Certainly. I think in general the DPUC is focused on ratepayer concerns as opposed to environmental concerns and environmental justice concerns. So that strikes me as different. Someone here can certainly correct me if I'm wrong, but I don't believe that Attorney General has been super involved in the Invenergy process, if at all, and I think he's come out politically with an opinion on the process.
Yeah, so he might have an ability, or he or she might have the ability to go in, but they're not, that's not that explicit.
Yeah.
Any other questions? Thank you very much. Medicare, getting close to
Thank you, Chairman, members of the committee. My name is Meg Kerr, and I'm the Policy Director at the Audubon Society of Rhode Island, representing our 17,000 members. We do support this legislation. We have not been deeply involved in this study commission. I just wanted to make a couple of points. So I don't have a tremendous amount of expertise in the area, but I do think I've been watching. We oppose Invenergy. We've been watching the process. This legislation, I think, takes the experience of this large power plant process in the state and applies it as we look to the future for additional energy facilities. And I'll point out that the EFSB has to review electricity capacity greater than 40 megawatts. We're seeing renewable energy projects being proposed right now for the state that are 40 megawatts and larger. So the need for the EFSB as we look to the future will probably be more around these large renewable projects. So I just wanted to make that clear. And the EFSB right now has 3 members, and 1 person is no longer in their position, so there's just 2 members. I think looking to the membership of the EFSB and making it more robust, whether 9 is the right number or not, I don't really know. I think it makes sense to add the health department, and there's logic in the members that are listed here. I think our position is that we need more than 3. 3 is a very small number, and as people have mentioned, there's a tremendous amount of information that has to be reviewed and digested, and a lot of expertise that needs to be available on the board, and by increasing the number of people, you achieve that. And I also would just point out that adding 1 or 2 people from the community does not give them the veto of the decision. It just adds the flavor of their voices. They still could be outvoted by the other members. We definitely, Audubon has been strongly in support of the Resilient Rhode Island Act, and Eugenia Marks worked hard on it when we originally passed it. We're very supportive of it. We think it's important that it be included in the EFSB review of energy facilities moving forward, so we definitely support that piece of it. And I'd also just like to reiterate what others have said about these advisory opinions. I have read the advisory opinions on the Invenergy plant. And it's disturbing to think, the DEM advisory opinion can't make a statement about certain aspects of the proposal because they don't have enough information. The Department of Administration's advisory opinion says the same thing. I think as we're reviewing these big proposals, and it's not Invenergy, of course, that we're going to be looking at moving forward, but let's say it's a large renewable facility, we need to have the developer provide the state agencies with sufficient information so they can provide an advisory opinion that's just sensible. And for them to not be able to really evaluate the project under their own statutes because they don't have enough information is just not acceptable. So thank you very much.
Questions for Mr. Thanks a lot, Hank. Next we have Lorenz Roy.
My handwriting is very bad. It's Savard. S-A-V-A-R-D. It's okay. Thank you for allowing me to speak yet again. About this legislation. I consider this legislation better 8 to 10 years late than never to have arrived. All right. This legislation doesn't apply to that which is in Burrillville right now. Okay. That's one thing I'd like to say. Also, I was at the opening statements of the Energy Facility Siting Board. And Mr. Blazer, the lawyer from Chicago, in his opening statements to the Energy Facility Siting Board said that this Burrillville was the perfect place to put this power plant. This is true. But the industry, that is, Invenergy, National Grid, Spectra, and others, have been planning this for years. I've been to many things over the past couple of years, and I think it was National Grid admitted that they do not take any step forward unless it's been in the works for 5 years, at least 5 years. So 5 years back, plus the 3 that we've been fighting, I don't know, it kind of makes it 8 to 10. All right, this legislation is too much, too late, in my opinion. Now, as rebuttal to, and National Grid is no longer here, and Mr. Sabatoni is no longer here, all right, but let me see. As far as National Grid is concerned, I'll come back to the bill, but I just want to rebut a few things, or things that bother me when I am testifying. I am a person. I am not an environmentalist. I do not know things that the union people come here and say. They're environmentalists, they're union, they're there for jobs. Why don't they say jobs? But no, they're talking about the ISO and the need for energy. I'm just rebutting.
I know, but I
Okay.
This is not instead you can rebut their statements, absolutely. But
Yes.
just do that.
Well, that's what I'm doing. That's what I'm doing. They are not in a position to be experts in the testimony. Okay. Well, that's in my opinion. National Grid also made a statement, and I'm just rebutting here, that they've had for their lines, they've had various meetings in the community and nobody goes. Well, maybe they haven't advertised. Very simply, they could advertise in a bill, right? Also, National Grid, the industry needs to get with the program. This power plant is so passé, if you allow me to say that. This is for 30 years, and we don't need it. In my opinion, everything is coming. Their ISO has reported that energy needs are going down. All right, a couple more things, if you allow me. Oh, yes, one good thing about this legislation is it'll be revised in 2 years. which is excellent, because in 2 years, when the the Clear River Energy application is denied, then there will be a need to revise this entire Energy Facility Siting Board bill. It will change to something that is going to be great. It's going to be great for renewables. Also, as far as the cars are concerned, oh yes, Mr. Mancini made a statement about airport and dumps, landfills, etc. I guess the landfill's pretty bad, but this power plant is an environmental disaster. Disaster. It'll set back renewables for a long time. Also, someone said about renewables aren't going to be good until we have some kind of battery thing fixed. It's already been fixed. Where have these people been? They're saying that they come here to testify that this and that and this and that. Battery technology is now the up-and-coming thing. So we will have storage for solar and wind and hydro and all of those things. So thank you for letting me rant on once again. Oh, did I say that? I think I did say that when this is denied, when this application is denied, we'll be back again here to revamp this bill. Thank you.
Any questions from Mr. Barr? Thank you very much. Next, Jocelyn.
Thank you, Mr. Chairman, members of the council. I'm very much in favor of this bill. In the interest of time, I won't go through every element because you've heard all the arguments. I do want to say one thing about the general purpose of the bill, and that is that 3 members means that 2 people can decide. And in a democracy, I frankly think that's ludicrous. And I think the expansion to 9 is entirely appropriate and is very necessary. The only other thing I'll take the time to say now is where I can speak from personal experience, where something you haven't heard yet. And that's to support very strongly the element of the bill that reimburses the municipality for the expense of supporting the particular energy facility that may be cited. I happen to live on Sherman Farm Road in Harrisville, which is where Ocean State Power is located. And I see the fire engines going up the street on very numerous occasions. It's just clear to me. It's a drain on the town, on municipalities, and I think it's very important, and I'm very glad that that aspect was covered in the bill, because municipalities should not have to take on the extra tax burden of supporting a massive infrastructure like this. And I'll leave it at that, again, in the interest of time.
Questions for Mr. Jocelyn? Thanks a lot, Doug. See you. Next, Alicia Kelly.
Hello, my name is Alicia Ann Kelly, and I'm actually from Scituate. So I'm not from Burrillville, but I have been entrenched in the Energy Facility Siting Act and the board, obviously, because of the proposed docket in Burrillville. But I want to take a step back and discuss a little bit more broadly about this bill and why I, left work early and I'm now missing a prior engagement to stay here. And I appreciate the 3 of you who have stayed as well. So I feel that there's always more to add or change. National Grid did bring up a good point as far as the transmission lines, and I think there's some work that could be done there. I would love to see over a certain amount of megawatts, a proposal that an environmental impact study would be triggered and required. But this is a good start. I've said in the past during commission public hearings that I recently turned 30 years old, and I feel that's significant because we're talking about a process that started 1986. I was born in '88, Ocean State Power. In the 30 years since it was cited, that process started in 1987, and the final hearings for that project started a month before I was born. So 1 year we went from the docket beginning to the final hearings. In Burrillville, that process, we just started final hearings last week. So the argument that, this is taking a long time, I think, is because the process is broken. And in the past 30 years, OSP has turned from being a baseload plant to a peaker plant, and that will be decommissioned within the next 5 to 10 years. So I've grown in 30 years, OSP has changed in 30 years, and this process and this act has not had significant change in 30 years. I agree with many people that the Resilient Rhode Island Act needs some teeth, and I think that this bill would solidify our commitment to that act. The ramifications of that are important, and they protect each and every Rhode Islander. The legislation also gives the host community a seat at the table. However, there are checks and balances that make this not be a NIMBY issue. So the EFSA was enacted in '86 to kind of combat NIMBYism. We can add, banana acronyms galore, but this allows for a more balanced approach for all parties involved. My wheelhouse is healthcare. I'm really excited to see that the Department of Health would also have a seat at the table. Anecdotally, I've seen waiting lists for preventative care to see primary care physicians, providers, be 4, 6, 12 weeks. And projects that are cited by this board do have an adverse effect on health. Healthcare, it has a cost to a ratepayer, a taxpayer, and a citizen. So I feel that having DOH have a say is encouraging. The EFSA creates a process that members of our legislative and executive branches have repeatedly told us to trust in Burrillville, and it's a process. It's antiquated, it's old, and it needs to be updated. I'm excited, as Lorraine said, that we're going to see it every 2 years being updated. Energy policy changes from 30 years ago to now, and it's going to change in 2 years because the technology is there. You know that, Chairman, as I believe in your private life. Really excited to see this, and I encourage this bill. I know it was voted for future study. I'd like to see it enter a full House vote so we can finally have a say in the process and have it changed. Another thing, too, is that there's only 3 of us who have spoken today that have not either been on the committee or have had a say, whether lobbyists or representing an entity. And we are the last, or I'm assuming 3 of the last people to speak. There may be, Ray and some other people, but 3 out of how many people have been able to speak today about this process that don't have a hand in the process? I think I've made my point that, we've tried to, our voice really isn't here. We only have 3 minutes to speak, usually during public comment. I actually timed my original speech, or what I wanted to speak to be 2 minutes and 30 seconds. I've obviously gone over that, but that's the process. There isn't a public, really a public say in this process now, and expanding that board allows that. And I really encourage the board, this committee to push this to a full House vote. Thank you.
Any questions for Alicia? Last,
Thank you, Mr. Chairman, members of the committee. Due to the late hour, I don't want you to have to buy the same real estate twice, so we'll just try to do a couple of issues. One is the 32 cities and towns, if you don't mind passing that down. That's the map. That's the green map of 32 cities and towns, plus towns in Massachusetts and Connecticut. And when we made those trips around and we split up and went all over the place, the main question was about local control. And the main question we got was, why don't you just vote against it? Because we don't have that right. So these changes get us closer to that, get us closer to local control. Because it's not a NIMBY issue, it's simply an issue of how we want things in our town. And one of the things that is a problem, and I see it as being corrected, is that, as an example, our comprehensive plan means nothing more than a submission from someone else. Someone can put in some submission, that's put on a pile with our comprehensive plan. We work very hard on that. We work very hard to make it work with the state, and it tells people what we want to be in Burrillville. And that comprehensive plan just gets piled up with a bunch of other stuff. That leads me to my second issue, which is the number of members. And the 9 members is a great suggestion because of 2 reasons. Number one, it takes away the political questions, if you will. When you have 2 people, that's a done deal. That's what they said when this thing started 4 years ago or 3 years ago in Burrillville. It's a done deal. Nothing can happen. Well, it's not done yet. So I think adding members takes away some of that skepticism. And secondly, the index plant, which was going to go in North Smithfield, was fought by both North Smithfield and Burrillville and defeated. That file was probably about this thick. As of the December meeting of the special committee, the FSB agreed that they have over 50,000 documents in this case. A document can be a page, it can be 30 pages. How are 2 people now? You had 3, now you have 2. How are 2 people supposed to read all this? I see it, and I got this the Evelyn Wood speed reading course going too, because we just get email, 30 pages, 26 pages, 9 pages. You know, it is impossible, ladies and gentlemen, for someone to do the job right. 2 people reading all of this and taking in all this testimony and doing an important job, running the PUC, taking care of state planning, running DEM. I mean, these are not like retirement jobs. These are real jobs with real responsibilities, and now they got this. So I think the 9 is crucial. To finish up, we heard a lot earlier about the need, which isn't part of this. But the fact of the matter is, talking about plants closing, local plants closing, and applying that to the need is like comparing, from a baseball perspective, on-base percentage versus sabermetrics. The ISO takes into account all of the factors that were mentioned here today, along with many, many other factors, and comes up with need. And as far as this nonsense is concerned about the sun doesn't shine, the wind doesn't, blah, 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 come on. I hear you talking, but all I hear is blah, blah, blah. Let's get down to the facts. ISO New England has said there's no need for this plant. That is a respected source. That's the kind of thing that should be paid attention to, not ridiculous nonsense about plants closing and blah, blah, blah. So, to finish up, I want to thank the special committee. I think they did a very deliberate, very professional job presenting something that improves the legislation, but yet doesn't shake the bedrock of it. They did take public comment. I gave some of that. They were very, very welcoming, and I think that committee did a good job. I think we should get behind this. I agree with the folks that spoke before that said, let's just put it up for a vote. Let's give it a shot. So listen, thank you very much, ladies and gentlemen. Thank you for your time.
Thanks. Any questions from Mr. Frank? Thank you very much. That was the last witness, so I explained to your... Oh, I'm sorry. Would you mind if I just... Please. Yeah. Thank you. Sorry. Is there anybody else in here? I just want to check. Okay.
Hi, my name is Steve Alquist. I'm a reporter, and I've probably written more on this plant than every other reporter in the state combined. And I just really want to come out and say that, contrary to what was said earlier about the EFSB being made to balance different concerns, when the EFSB was first proposed, I went back to a journal article to find this information because there is no information about the legislative intent that's kept as a record from bills that time. We have Victoria Liederberg, who was a senator, and a judge, and a very impressive person who was putting this out, and she's called it one-stop shopping for power plants. It wasn't about making something that was going to balance different concerns. In fact, it was intended to override the DEM's authority to reject certain plants in certain areas. In fact, the DEM had an official in the room when this was being passed, and he's saying to himself, or actually out loud, while the Providence Journal reporter was there, he's saying, what's going on here? Is this being done to override DEM? And he was told, no, DEM has a vote. But they put on the PUC and they put on Department of Planning, so there would be 2-1, so that DEM would not be able to take into account environmental concerns. So that's, I think, an important context to know what this original, still existing legislation is made to do and what it does. It does not do anything for the environment, doesn't really consider that, except the DM is there saying what they're saying, and then they're immediately overridden by the two people who want the plant to go through for whatever reason. The other thing I wanted to bring up was about the idea that ISO has shown that they've done an operational fuel security analysis, and just today a new report came out that showed that their assumptions that they used in January to make this report were wrong. And when they reran the models, they found out that they actually don't. They're 10 years from now, we'll be fine. There will not be rolling blackouts. These things were wrong. ISO has been compromised because their leader, Gordon Wheely, or Van Wheely, is a person who promotes natural gas. He's not supposed to, he's supposed to be neutral, but in reality he doesn't. He has his fingers on the scale. And I think that's the way it was exactly described, the fingers on the scale for natural gas. He's a proponent of natural gas, and he wants bigger and more massive pipelines, even though as an ISO CEO, he's not supposed to have an opinion officially on the source of energy, only on the transmissions and stuff like that. So I think those two things are important to understand in the context of this ongoing discussion. That's pretty much all I had to say.
Any questions for Mr. Alvarez there? Thank you very much.
Thank you.
Now that, I believe,